Welcome to the Kessler Law Firm podcast. If you'd like to connect, you can find the link to our website along with directions to our office in Fort Pierce in the show notes of this episode. Attorney Michael Kessler has been providing criminal defense and protecting the rights of citizens on Florida's Treasure Coast since 1985 and has been designated by the Florida Bar as a board-certified criminal trial specialist. With a solid record of success spanning over 40 years, attorney Michael Kessler has proven that more people are wrongly arrested for drunk driving than any other crime on the books. And now, here's Michael Kessler.
All right, folks, we got a real treat this afternoon. I am joined by my friend and colleague, Cliff Barnes. Cliff and I have known each other for more years than either one of us will admit. For a long time, Cliff was a very successful and distinguished and sometimes feared criminal trial lawyer here in Fort Pierce. And then for some reason, he decided to give up the law completely and he became a judge. After about a dozen years on the bench, he decided he was done with the black robe and the gavel, and he is back in the trenches fighting the good fight. Good afternoon, Cliff.
Afternoon. Nothing more fun than being in the middle of a good fight.
Well, you and I were talking the other day about when involuntary intoxication can be a defense. You used that as a defense at a recent trial, didn't you?
Actually, in a DUI trial, I would say it was one of my best results.
Yeah, I lost a bet on that case.
In a DUI case, of course, intoxication is what the state has to prove. But in my case, the defense was that the defendant had been slipped basically a date rape drug or a roofie while he was eating dinner and got up to use the restroom. We had no proof of that. We had no video of that. No witnesses, and he couldn't even say he was slipped a drug, but his behavior afterwards was such that my expert, our friend, was able to say that his behavior was consistent with somebody who was on that type of a drug. To make a long story short, he was driving down the turnpike in the wrong direction, which is hard to get on the turnpike in the wrong direction to begin with. But once you're on it, you should be aware that all the cars coming and flashing their lights and running off the road are trying to tell you something. But he was driving straight and narrow, the speed limit. He never weaved. He never crossed the center line or the side stripe, which is consistent with that type of drug where your fine motor skills are great, but you just don't know what planet you're on.
You know, they say there's never a cop around when you need one. Wasn't there a police officer following him?
We had a video from the trooper who was disciplined for going the wrong way himself, but there's no telling how many lives he saved by running my guy, pitting him, running him off the road and eliminating his threat, because my guy had gone about 20 miles.
Well, let me see if I understand this right. Your client was driving the wrong way on the turnpike.
Correct.
He was driving at a legal but high rate of speed, 70 miles an hour.
Yes, but posted speed limit, correct.
Okay, so he wasn't exceeding the speed limit, but he was going pretty darn fast, especially to be driving in the wrong direction.
Correct.
There was oncoming traffic.
Lots of semis and passenger cars.
And despite the best efforts at signaling, well, tell us what the police officer did to try to persuade him to pull over.
Well, the trooper got behind him. My defendant's windows were down, so he obviously could have heard the siren behind him. He also had his takedown lights, blue and red takedown lights, flashing.
So there he was. Your client was driving with a police officer behind him, lights flashing and siren blaring
for several miles, and he had already been driving for about 15 or 20 miles.
How many miles altogether did you determine that your client had been driving the wrong way on the turnpike.
26 miles.
26 miles. So eventually the police officer was able to pit him and get him off the road.
Correct. And then the client started driving in the right direction and had to be blocked by another patrol vehicle.
It seems like there was no question that your client was extremely impaired or intoxicated.
No question. And of course, we agreed with the prosecutor. We conceded that fact.
So explain to our viewers, what exactly is the defense of involuntary intoxication? Or more importantly, why is that a defense or excuse to driving drunk?
Because at least several Florida cases have made it a defense to because it's basically a mistake or an accident that you became impaired. You can't say, "Oh, I drank, I thought I drank 2 beers and I really drank 6." That's not a defense. I took my medicine, but even though it says on the bottle not to drive, I didn't think it would hurt me to drive. That's not a defense. But in this case, he had no idea that he had been slipped a drug. The last thing he knew, he was eating a hamburger and drinking a beer at a restaurant in Palm Beach County. And then the next thing he knew, he wakes up naked in the St. Lucie County Jail. He had no memory.
So as far as your client knew, when he got behind the wheel, he was completely sober.
He has no memory. The last thing he remembers is getting up from his meal and his beer and going to the restroom and coming back, and that's all he remembered.
Well, did you all figure out that that was his one and only beer?
We did not. We had no video. By the time I got involved, it was a year down the road. The other lawyer had said, "I can't really do anything for you," and it took me a while to figure out the proper defense as well.
Well, so I'm trying to focus on the defense. It, to the best of your client's memory, was he sober when he got off the bar stool and went to the restroom?
Yes, yes. He had just gotten there, been served a hamburger, and was starting on his beer. If he was telling the truth. I mean, we don't know when our clients tell the truth or not, but if the jury believes them and we're not putting on perjured testimony, then they're allowed to believe it.
So as far as the evidence goes, there was no evidence that he had more than started that one beer along with his hamburger.
Correct.
Okay. And so because becoming intoxicated was something that happened to him against his will because he was drugged, it wasn't his fault that he was drunk.
That's correct. Yeah.
Okay. Well, that's an interesting defense, and you did a great job at the trial, winning that against all odds. I'm intrigued by the defense itself, though. Is involuntary intoxication a defense to other crimes in Florida?
Anything with a specific intent. And DUI, I didn't, until I started researching it, I didn't know that it was a defense to DUI, because DUI doesn't matter what your intent is. But Florida courts have ruled that if you legitimately didn't know that you were taking whatever it was that made you intoxicated, then that's a total defense. But yes, any intent crime, let's say a grand theft, you intend to deprive somebody of a piece of property. If you're so drunk that you don't know that it belongs to someone else, or you don't really have the ability to intend to deprive them, it seems like that would be a defense as well.
So there's a case pending somewhere on the Treasure Coast now. A fellow was at a sports bar on Super Bowl Sunday, and his team was getting the living stuffing beat out of them. And the longer the beating went on, the more this fella had to drink. He got apparently so drunk that when he crossed the street and he walked into the fire station, he thought it was open to the public. Turns out it was not. Is his intoxication a defense to a charge of trespassing or burglary?
No, that's voluntary.
The intoxication is voluntary.
Yes. It's
So
not
he may,
involuntary intoxication.
okay, so he's intentionally drunk.
Which negates the involuntary intox.
Okay, so the nature of his intoxication, the fact that it was voluntary, means that's not a defense to him going into the fire station.
Correct.
Now,
But
if he thought the fire station was open to the public and therefore he was invited to go in and he turned out to be mistaken about that, that's a defense. It's just not the defense that we're talking about.
correct.
Okay.
And I want to say one thing. I don't know how long we're going to be on, but I think I've had lawyers and read about lawyers who say, yeah, my client says that they don't know, somebody slipped them this or slipped them that, but that'll never go. That'll never, no jury, no judge will ever buy that. And I kind of believe the same thing, although I was sure I was going to win this after I took depositions and the trooper said it was the first time in his 23-year career he had ever seen anything like this. It arrested a lot of drunk drivers. He had just never seen someone able to control their car the way this man was the whole time he was following him. And yet, when he stops him, he doesn't know where he is. He's urinated himself. He's totally unable to communicate. He was so intoxicated. So I've had lawyers and read about lawyers who say, yeah, no one will ever believe this. Well, in my case, they believed it. And I had a good expert. I had a very sympathetic client with no prior criminal record. And here's what I found. You know, you and I both know sometimes we get educated when we're picking juries and we ask the voir dire questions, which is just asking them questions about what they buy, what they wouldn't buy, how they live, their values, that type of thing. And I asked the jury, first of all, you men, how many men out there would walk away from their beer or their cocktail and not keep an eye on it and then come back and pick it up and drink it? And like half the men said they would do that. They would feel comfortable drinking it. None of the women said they would ever drink their beer or their cocktail if it hadn't been in their possession or their best friend or somebody they trust possession while they were away. And so I asked about 40 people is in my veneer. How many people know anyone, close family or friends, that has been slipped a date rape drug against their will? And about a fifth of them raised their hand, and 2 said it had happened to them. So this is a defense that lawyers need to understand is believable, because the general public knows that this is going on. They know that although it's called a date rape drug, it's not just a date rape drug. It's, if you want to cause someone unbelievable grief or even death, you can do that by putting something in their drink. You don't have to want to have sex with them. You might want to just see if they can get home or whatever terrible thing could happen to them.
And we've both read and talked to people that were involved in cases where a person got robbed or mugged and the victim was given they used to call it slipping them a Mickey.
Yeah, it's been going on for years and years, but nowadays jurors are receptive to this defense and lawyers don't think they are. So the word needs to get out that if your client tells you something, believe them and try to build. It would have been good if I had had a video, or maybe not good, depending on what the video would have shown happened at that restaurant. But every restaurant has a video now, every bar, for their liability insurance.
Well, I think, Cliff, I appreciate your help today. I think there's three takeaways at least that I've gotten from listening to you explain this. Number one is lawyers need to understand that this is not just a theoretical defense, it's actually a defense that could win at trial. Clients need to understand that if you think this happened to you, you need to tell your lawyer. Don't be embarrassed by it. Don't be ashamed of it. Tell your lawyer, because it may be a complete explanation or excuse for whatever happened. The third thing I would say is if you're drinking, especially if you are a wine drinker and you're sharing a bottle of wine with whoever you're with, keep an eye out, because servers often will top off your wine glass and you might end up drinking quite a bit more than you thought. And that is not involuntary intoxication.
That's voluntary intoxication.
That's voluntary. If I think I had 2 glasses of wine, but with the help of my server, I really had 4, that's on me.
Absolutely.
So if you're drinking wine by the bottle, keep an eye on the server. They're not trying to be evil. This is not like a date rape drug. They're just trying to be good servers and not interrupt your conversation while they top off your glass. So that's the third thing I want you to be aware of. Is there anything additional, any other lessons we can highlight for our viewers?
Too many times lawyers get wrapped up in legalities, and we're in a mindset where we don't listen to our clients. So listen to your clients as lawyers. Because I listened to this young man, we beat a 15-year felony charge that would have resulted not only in prison time, but him losing his license for 5 years. So only because I listened to him. The lawyer he had first just told him it was a loser. They got a video of you going the wrong way, and they got a video of you falling down and slurring your speech and urinated yourself. What do you want me to do?
Well, I appreciate that. And thanks for giving us your time. Thanks for coming in and talking with us this afternoon.
Thank you. Always good to visit.
And we'll have you back again.
Thank you. I hope so.
Thanks a lot, Cliff. And I think that'll do it for another episode of the Kessler Law Firm podcast.
Thanks for listening to the Kessler Law Firm podcast. If you'd like to connect, check the show notes of this episode for a link to our website and directions to our Fort Pierce office. Whether you're watching this on YouTube or listening to it on your favorite podcasting site, please click subscribe or follow so next time you come back, our podcast episodes will be ready and waiting for you.